allowed Democratic state courts to replace congressional redistricting maps enacted by Republican legislators. And the court shows no signs of slowing down. In a case against Harvard and North Carolina universities argued in the fall of 2022, the justices will decide whether schools can continue to consider race when admitting students. Also, in the 2022-2023 term, the court will review whether the government can use environmental laws to limit the right of property owners to develop their land. It will further address whether individual rights to privacy extend to new technologies, such as smartphones and self-driving cars, and whether social media companies must recognize free speech rights for their users. Not only has the court expanded its powers to decide many of our society's fundamental questions, now most Americans seem content to have judges rather than elected politicians make the calls, at least until a Supreme Court decision doesn't go their way. These cases, and others spanning sex, race, religion, and speech, underscore the court's unmatched influence over American society. Its authority to say what the law is, as Chief Justice John Marshall put it in the foundational 1803 decision Marbury v. Madison, has placed it at the center of our nation's most controversial and sensitive issues. But this great power comes at a price, because our founders created a Supreme Court deliberately insulated from political influence. Once nominated by the President and confirmed by the Senate, Supreme Court justices serve for life at a salary that cannot be reduced. Unlike presidents and members of Congress, federal judges need never return to the people for approval of their actions. I'll see you in court. There is hardly any political question in the United States that sooner or later does not turn into a judicial question. A keen observation of French thinker Alexis de Tocqueville in 1835, after he traveled throughout the United States investigating what made the New World so different from the Old. If the justices get the wrong answer, or even worse, substitute their own ideas for those of the founders, the American people can reverse the error only by amending the Constitution, something that requires the approval of 2/3 of the House and Senate and 3/4 of the state legislatures. The states have never used the alternative procedure, which requires them to call a convention. Rather than mount a challenge to the court, our presidents and Congress defer to the justices to settle our most divisive national controversies. Whereas 100 years ago there would have been a lively debate over the court's power to reverse the decisions of elected legislatures, today debate concentrates instead on which laws the court should strike down. Nevertheless, the anti-democratic or counter-majoritarian feature of striking down acts of Congress, the President, and the states remains the central challenge posed by the nature of the Supreme Court. Americans must constantly reconsider whether the power to block the will of the majority should rest in the hands of 9 judges who, after the President is nominated and the Senate confirm them, enjoy their jobs for life. Nice work if you can get it. Supreme Court justices have job protections that would make a tenured professor or unionized teacher blush. My, how things have changed. The court's supremacy in our lives is recent and runs counter to American history. Abraham Lincoln, for one, did not believe that the Supreme Court should have the vast power that it wields today. Lincoln rose to prominence because of his opposition to Chief Justice Roger Taney's opinion in Dred Scott v. Sanford that blacks could never become citizens of the United States and that the federal government had no power to limit the spread of slavery in the territories. In his first inaugural address, delivered even as the South descended into secession, Lincoln made clear his opposition to the court. I do not deny that such decisions must be binding in any case.